Hello, everyone. Rilus Dana here. Let me finish setting up the stream. Push the button over here on Instagram. There we go. Live on Instagram, Facebook, YouTube, LinkedIn. Welcome, everyone, if you're watching live or from the future. Go ahead and leave your comments. If they're related to the topic, I'll try to get to them. If you're watching live here or even on the replay, I'll try to answer your comments and questions. So with Valentine's Day just ending, today's topic is about prenups, marriage plans more specifically, which is when you combine an estate plan together with a premarital agreement. So if you got engaged over Valentine's Day, if you're planning on getting engaged or married in the future, this is going to be an important topic for you, especially if you're watching in Arizona, California, or the community property states. So we're going to be talking about those default community property rules. So let's get into it. Let me share my screen here. Let's see. There we go. So that's where I practice law. Oops. So I practice law, Arizona, California. So what a marriage plan is, it's an estate plan. So we're going to emphasize the positive. It's not just the negative, what happens if the relationship ends. A marriage plan is also just to have a plan. Who's going to do what? Who's paying for what? Where do things go? So it's an estate plan plus clarifying the rules and opting out of the default rules with a premarital agreement. So first, let's define the community property rules. Then we'll talk about the prenups, and I'll show you an estate planning option that I like to use for couples that are into a second relationship or coming into a relationship with assets and children. So community property, it's all property acquired during the marriage except gifts. So everything that you acquire during the marriage by default is community property unless it's a gift. So let's go through that. So here's Mr. Estate here. He's got a bank account and a house. That's his separate property. Mrs. Estate, she's got her bank account and IRA, her separate property. They get married. So the community is created. Once they get married, there's now a community, and any assets acquired from this point by default are going to be community property. So let's say he gets a paycheck from his job after they're married, puts it into his separate property bank account. Is that his separate property? No, it's not. He doesn't exist anymore now that he's married. So the income from his job it belongs to the community. So even though he put it into a separate property bank account, the community has an interest. Now she's got a job, puts it into an IRA. So same thing, even though it's in her IRA, that's from her efforts during the marriage. So by default, that part is community. So you can see here where it can get pretty tricky. Since everything acquired during marriage is community property, people don't realize that if they're putting it in their separate bank account, it's still community property. So let's say he sells his house. He decides to sell this house that he had before marriage and buys a new house. So what happens to that? If he buys it in both of their name, then it's community property. It depends on how he takes title. Now, if he takes title in his name, but he gets a loan, this IOU, he gets a loan, again, loans in his name, title to the house in his name, and then from his job, he makes a payment on that loan. Well, guess what? The community made that payment. So the community has an interest in this house. So you can see it can get really complicated if you're bringing assets into a relationship. If you have a house that has a mortgage on it, by default, it's becoming a community property asset during the marriage. All right, let's talk about gifts. So Mr. Estate, his parents have a trust. They pass away. He inherits some money. What happens to that money? Well, it depends where he puts it. If he puts that money into a joint bank account, then it becomes community property. Now, if he puts that money into a separate bank account, or if he opens up a brand new bank account, then it's a separate property. So he didn't earn that money during the marriage. A gift or an inheritance is separate property. Okay, so community property is everything except for if it's acquired by gift, devise, or descent, or after divorce or a petition for divorce. Now, what about a business? So if you have a business, this is another really good reason to do a prenuptial agreement. Now, if the business grows during the marriage and then the relationship ends, the marriage ends, what happens to the growth in that business? Well, it depends. So it's either if that growth was due to the efforts, then that growth belongs to the community. But if it's more passive, then it's considered separate property. If it's just like owning a stock that you owned before the marriage and you didn't do any work, then it stays the separate property, those gains. Same thing in California. It's either the efforts they look at or if it's passive. So this is a really good reason to keep the lawyers out of it. You can see that it could be really easy to argue one way or the other, whether a business grew because of efforts or because it was passive. So a prenuptial agreement is a good idea to opt out of those default rules. So let's take a look how you do that. So we just defined the community property rules. That was fun. Now let's look at premarital agreements. So prenup means before the wedding, in consideration of marriage. By doing the agreement before marriage is the consideration. So after you get married, there is a thing called a post-nup, but I don't think they work as good, at least in the states where I practice, Arizona and California. So you want to do it before the wedding, prenuptial agreement. It's got to be a written agreement, understood by both parties. So that means they had enough time to look at it. It's in their native language, and they're also represented by a lawyer. Because how else are you going to prove that someone understood an agreement? Really, the only way is to have a lawyer represent them and sign off saying that they explained the agreement to them. So common mistakes that make agreements unenforceable. If you don't disclose everything, there has to be full financial disclosure. Anything that's unfair to one party, if they didn't have a chance to consult with an attorney, not enough time, or duress or coercion. Okay, so now let's look at some estate planning options. Before we do that, let's talk about a deed. Let's clarify a deed is the ownership of real estate, the ownership of real property. And if you have a loan on it, then that's debt. So the mortgage, it's secured against the property. So the deed shows the ownership, the mortgage shows who owes the money, and it gives security interest. So there could be several mortgages or even judgments or liens against the property. Okay, so this is two single trusts. So Mr. and Mrs. Estate here, this example, they each have kids, their own set of kids before the relationship, and they each have an IRA and some assets. So they create a trust. They're each going to create their own trust. They're going to be the trustor, the boss of their trust. They're the trustee that manages, and they're the beneficiary of their trust. Unlocked, meaning revocable. They're going to choose who's going to manage their trust when they're gone, and where it goes, and when and how it gets there. So this example, they buy a house together, and we put an interest of the house in each of their trusts. This may be 50-50, or sometimes it's a different percentage, depending on who's paying for what and how it's going to work out. They also put their other assets inside of their trust, and they can choose the beneficiaries. Maybe they list things to go to their kids, their partner. Same thing with their IRAs. The IRA beneficiary, you can choose directly your kids or your partner or some combination. Okay, so Mr. Estate passes away. So successor trustee of his trust is appointed, and they're going to distribute his assets accordingly. Now, this life estate, what that means that Mrs. Estate over here can live in his share of the house. So this gives her security that the kids can't sell the house and kick her out, or they can't move in. And it also gives his kids security because she can't sell the house, or if she does, they'll receive their share. So this works really good. It's a good way to take care of your partner, but not their next partner. Now, once she passes, then the house is sold. His share goes to his kids, and then her share goes to her child. So that's it. That's marriage plans. So pretty easy. Want to emphasize the positive. It's a good idea to have a plan so the relationship can succeed. I don't want to just emphasize the negative, what happens if the relationship doesn't work. But it's a good idea to clarify, especially if there is a house or things that you're bringing into the marriage, what is the plan? Who's going to pay for what? Who's the owner of what? What would happen if you pass away? Now, marriage plans, prenups can be kind of an uncomfortable topic. So let me bring it up. So the beauty of a marriage plan is it's about the positives. It's about everything you need for the relationship to succeed. By including your partner to your estate plan, that's a really caring gesture. And that's how it starts. So we'll start off by showing how you want to protect your partner if you were to pass away, and how you do that. And then also you let me I'll bring up the need to opt out of the default rules of the community property. A prenuptial agreement doesn't do you any good if you can't get it signed, and if you don't follow the proper formalities, where it's reviewed by an attorney and all of those things. Hope you found this helpful. Let me know what other topics you'd like to hear about in the future. We'll see you next time.